Hello, welcome to Tech Tuesday number 79. And today we're going to talk about personal heuristics for IP. But in particular, we're going to talk about executives. So I've given lots of talks about IP to management, to founders, people who are not IP people. And I'm sure I'm going to give more talks. Because this issue of non-IP people understanding IP is super important. And I'm always evolving my talks because I keep on learning. And for example, I learned, surprise, that CEOs need to look at IP differently from IP people. So when you talk to CEOs, you don't tell them a patent is a document with claims at the end and Paris Convention and so on. But still, all of these talks appear to be like some sort of abstract doctrine. And it's not only that you have to be careful to use business type language or talk about concerns of business. I think that IP issues need to be matched, like impedance matching, to the way that a CEO thinks. And that means style, yeah, but also the necessities. And what it really means, because a lot of CEOs are very practical, I'll call it. What do we do now? How do we solve this problem? And so on. When you do IP education, and this is what these talks are all about, they should be able to answer a particular situation that is on the mind of that executive. And that really means that any principles that we teach them, they need to be easily retrieved when it's appropriate for the CEO. So, one way of perhaps doing it is telling stories and hoping that the executive will recognize that the situation they are in matches some cool stories that we told them about how Microsoft took over the world using IP tricks. And most important, you want IP to be an equal player with other considerations such as finance or marketing, so that when the CEO is thinking about whatever they're thinking about, IP and marketing can compete with each other, as they should. And that leads us to the question, what should a CEO actually understand about IP? And before you say, but they have great IP advisors, like all of you listening now, I want to remind you that these IP advisors are not always in the room, and they're definitely not in the head of the CEO, who, for all you know, is planning the strategy for the next 4 years while taking a shower. So I didn't draw the scale, but imagine a scale. On one end is a CEO who maybe knows how to ask, what is IP? And on the other end, the CEO is an actual IP strategy expert. And we ask ourselves, okay, where on this scale should the CEO be? And what does that mean? It means what kind of knowledge and skills should they have? Now, I'm not going to answer that question, but I think we can agree that we don't want the CEO to be an amateur IP specialist. They don't have the time to do that. And amateur is amateur. And let's say there is an ideal place for the CEO to be. So obvious questions are, how does the CEO get there? How does he stay or she stay at that location? And how do they even know that they are at this ideal location? And if there is no ideal location, what is the risk of each one of these positions? Now, guess what? I'm not going to answer any of these questions today because I have different fish to fry. A related question is, does CEO always get better? We learn with experience, we get better like good wine. Or maybe not. What if the CEO has a wrong kind of experience? What if they move to a different field? What if the world changes? Okay, so it just gets more and more difficult answering this question of what should a CEO understand about IP? Now, the general answer to that question is that they should understand how to use IP to do their job better. That's not a very useful answer. But I saw this paper. There was a whole issue about where do good strategies come from. And this paper had some interesting insights, and I recommend reading it. But in particular, in section 3, and this is not a paper about IP, it's about business strategy. Superior strategists develop a thin playbook of simple rules and then improvise in real time. Okay? And then I said, maybe our job as IP people is not to teach generic IP tools to CEOs in hopes they remember them, but rather for each CEO, for each situation that they're in, for their company, give them a small number of rules to follow. And these rules are how to use IP strategically, not what is IP or how to look at IP. And if we do that, that could be wonderful. And some of these rules are questions they should ask. Okay. And some of them might be, this is a very important issue. And some of them might be an identification of an important IP issue that they should be considering. But I'm going to go into more details on all of this. So why does this even make sense that different companies should know, the CEO should know different things about IP? Well, let's just compare startup companies to established companies. Startup companies care about growing. If they don't grow, they really shouldn't exist. While an established firm might care more about how much money do they make, or just, staying in the middle, staying the same size, staying alive. And I'm quoting here from the article, our perspective, and he's talking about startups, growth is a primary performance outcome, contrasting with positioning's emphasis on profitability. Okay, there's a whole class of strategy types called positioning. You position your company in such a place that it's going to win and everybody else will lose or bow down to them. And then he talks about why simple rules are useful. First of all, they help you decide quickly. And when it says strategists, he really means CEOs. 2, it makes it easy to communicate to other people. So you get coordination. And 3, you get balance between capturing what you expect and capturing what you don't expect. Now, whatever rules we do, I hope it's clear, they won't be perfect and they definitely won't cover all situations that the CEO might meet. And if the CEO was actually listening during the lecture on what CEO, founders, and managers really need to know about IP, I have a 20-minute, 50-minute, 2-hour lecture on that subject. If they were really listening, they could do a better job. But if we give them a thin playbook, then first of all, they have rules that they actually have them, understand them, and use them. And there's hope that if they actually use these rules regularly, it will change the company culture with regard to IP. So I talked about personalization and what can a rule depend on. And I'm using the words rules and heuristics interchangeably in this talk. So first of all, each particular company has its own set of rules, but similar companies, let's say 2 medical device companies making an implant which solves only a single disease and has no other application, they might need similar rules. Not the same, but similar. The company itself, it has a culture, it has a particular technology it's in, and it has whatever gives it competitive advantage. The executive, different executives have different personalities, different knowledge, skills, and experience. Difference between an executive who was sued and his company shut down because of it, sued for IP, and an executive who managed to sell his company, even though it had no IP, is huge. the market, the type of customers, the structure of the market, how many competitors are there, and so on. The strategies that the company is using, and when I say strategy, I mean business strategy. It can be a product strategy. It can be how to sell the company itself. It can be how to interact with the ecosystem. And not to forget, IP is not critical for success of all startup companies, or it's less critical. Last but not least is competition. Depending on what your competition looks like and how aggressive they are, IP will take them differently into account, and therefore the rules will as well. First question we ask, does the CEO actually have a strategy? Do they know what their market is? Now, before we pile on CEOs who don't know how to do their job, let's remember that one of the things that a startup company has to do is discover its market. People call it product market fit. It needs to figure out what strategy will work. So even if the technology is exactly the same, it can be a completely different company. Now, in particular, you can look at it as a company has some sort of maturity curve. And as a company matures, also the strategy phase changes. And this is some work that Tamir Ben David is doing with me. Now, it means that at each stage of the company, the CEO is looking at his strategy in a different way, and the job of IP is also different. And just to give you a feeling, if you're at the stage where you trying to get the technology to work, you're looking at strategy completely differently from when you are fighting with your competitors, or when you're scaling your company, or when you're trying to understand who you can partner with. So I started preparing the presentation saying, okay, it's going to be about CEOs because they're the guys with the money and the power. And then I read this post by Layla, and she pointed out something which we all know but may not think about all the time. The different executives in the C-suite have a different way of looking at IP. So the CEO might look at it as a tool for competitive advantage, and the CTO as something which affects the technology roadmap, and the CMO is thinking whether it can help them with their branding and positioning activities. Now, I agree that most of these people don't think too much about IP, but if you manage to start this process and the company does have a good IP culture, each one of these executives probably needs different personalized rules. But as I said, I'm going to focus on the CEO. Why? Because IP is a strategic tool or strategic liability, depends which one you do. And that's what the CEO is in charge of. So I talked about personalizing the rules, but let's first see what non-personalized rules look like. And one of the ways that we know that these are generic rules is because you have no idea if these are any good without knowing the context. They sound good. For example, what is the cost benefit of this IP? That sounds like a great rule, except maybe it doesn't matter. Maybe the IP is so cheap you don't have to talk about it. Maybe the problem is not this IP, but vulnerability. So we don't even have to talk about the value of filing a patent. Another rule, protect using a mix of patents, secrets, and know-how. It's a great rule. I wish everybody used it, but it's not part of that thin playbook, and it's definitely not tied to any company. So if you could apply these rules to any company, any person who walks through the door, they're probably not personalized IP heuristics. But these are all important rules, and everybody should follow them. Now, in my own practice, I push the following generic rules or questions to ask. CEOs make decisions. Well, does this decision generate IP? Does it affect the maintenance of IP? Are you avoiding an IP risk or not? And again, these are generic rules which are important and valuable, but they don't suddenly snap into view. They're not very detectable, It's not easy for naive operator to know that they have to be applied. And it's not clear exactly what you need to do in response. Let's look at something from the previous page. Does this IP affect my moat? We can ask that. It's an interesting question. But how about this one? Does this IP strengthen my moat? Okay, imagine two companies. One of them has a weak moat, and the big IP issue for that company is, can we make that moat stronger? And a different company has a great moat, and the big question is, will something happen? And when that something happens, it will weaken my moat. So I just, by narrowing the question a little bit, it got better. Still, it's more a principle than a rule what to do. And here's a further focusing. We talked about the companies that has a weak moat, and maybe the big question, the big IP challenge for that company is its moat is only good against a particular technological solution, but alternative technological solutions might bypass the patents completely. Okay, and we all know companies like that, just in the medical field. Um, you think of Viagra, and they were passed by Cialis because Cialis is an alternative technological solution to the same problem. So the questions that Pfizer were asking is, can we get IP to prevent people from bypassing us with alternative technology? So when you identify specific IP-related risks and the company strategy, which in this case is strong moat, it brings to this question. But the questions don't have to necessarily be so IP-like. Imagine the following alternative question. Does this, and I'm not saying what this is, temporarily extend our moat using IP? In other words, our moat is good for 5 years. Does this make our moat last 10 years? Okay, it's a very specific question. And if you think about a company which licensed technology from a university, and maybe they licensed it 10 years after the university developed it, and it's a new startup, it's going to take another 5 years to get to market, at least, I'm being generous. So already 15 years of the patent term are dead. So the big questions that should be on the CEO's mind, whatever he does regarding IP, is I need to extend my IP moat. Will whatever I'm doing now, signing a license agreement, taking a partner, whatever it is we're doing, will it allow me to extend my moat in time? Very specific question. That's a question we want him to ask for her. So I want to give you an example of a company, and any similarity to existing companies is completely random. So let's imagine we have an IP pioneer which is developing a new interface for AI. Let's say one with a direct text-based dialogue mechanism. And the goal of the company, the strategic goal, is to control AI development by having a technological lead, which you have both using business tools and leadership sharing of technologies. So I made up 3 rules for the CEO of this company. The first one is, if we have a new public-facing advantage, meaning that people can see that we have that advantage, are we going to leverage it or just protect it? Protect it means other people can't copy it. Leverage means we make it punch above its weight. Another rule, if we discover a new, or if we need, critical data source, we need to look at whether IP laws help us or not. Okay, let's say we want to scan all the books in the world and use that to generate answers and have better text dialogue. Do these IP laws interfere with us? Might we have to pay $1.8 billion in a settlement, just so we don't make it all the way through court and discover we can't. Okay, Anthropic did it. I think it's Anthropic. And let's see how we apply rules like this. So the CEO is now thinking of providing this dialogue mechanism for health. And obviously it uses a new data source, which is medical records. And maybe you can only get them by licensing. So you have to have a licensing agreement. Licensing agreements are always about IP. Now, if you're going into health, you have a flywheel. The flywheel is based on people using your system and giving you feedback and you improving your system. And in particular, when we're talking about health, one of the problems is safety risk. Either people die or get harmed by your system. So if we can identify these safety risks, we can protect them. And I'm talking about safety of the dialogue system, and that will protect our flywheel. Okay, giving us an advantage over the competition. Now, I'm not sure if this question of how do we build a better flywheel or moat using IP for this new market we want to get into, health records, is on the radar of this hypothetical executive. And here I have a completely different company, medical device. Let's imagine there's some element you can put outside an artery and it improves the blood flow inside the artery. Guess what? Our body is full of arteries and full of diseases, and there are a lot of different arteries in the body and diseases that could be affected by it. So here's some rules. New medical use identified, check exclusivity potential. Okay, just because we can solve the problem doesn't mean that it's good business. Or let's look at the last one. You have external collaboration planned. Could it create something strategically important? In that case, before you even start, make sure that you preserve the rights. You notice the word IP didn't really appear here. And here we have an example about a collaboration and how you would apply these rules automatically. It will be triggered automatically. Are these rules only for executives? Let's talk about inventors. Often we have inventors asking, how should I know if I should come to you? And today we use generic rules like if you have something new and appears to be interesting, difficult, valuable, flag it. Okay, that's a very general rule. And it's not clear how they know if something is patentable before they talk to the patent attorney. But what if the inventor is told, flag any insights relating to how X, whatever it is, does Y? Okay? That's different. And here's another rule, which is people don't understand. Note that how the technology, and here you say which technology, is used and its advantages are secrets. Some inventors, engineers, think that if they only talked about the advantages but didn't say how you do it, it's okay. Depending on the situation, this is the rule you'd want to give them. Now, what's tricky about it when we talk about inventors, what makes an invention valuable? The answer is that it can be used to apply leverage at some control point. I'll talk about that in a few minutes. And identifying what the control points are is often just as valuable as making the invention. And depending on the inventor, you should or should not ask them to do it. And of course, anybody can be an inventor, but you knew that. What about support staff? Consider the outside patent attorney. Me. I work with a lot of companies. Each company I work with needs to be analyzed for its own IP-specific issues. And I admit that there's definitely a tendency to look at companies in a generic fashion. Oh, that's a standard medical device company. Oh, it's another cyber tech company. And what we really need to do is identify the specific IP challenges, vulnerabilities, and opportunities that a company has. If you formulate them as rules, small number of rules, it's more likely that you will capture what's important when you're dealing with a company. Now, it starts just when you start. The company starts, comes into existence, what we call day zero, before there's a company. That's the day you start asking these questions and start formulating the rules. And as you realize, the rules change as the company changes and matures. Now, in-house people have it much easier because they only have one company to focus on. And they can probably use a longer set of rules, instead of 3 to 5, 10, 20. But they need to remember that the different executives they work with need to be told about different rules. So you've probably heard me talking about rules, and you might be tired of it. And you're asking, well, how do we create these magical rules? And I'll admit that I can't promise you that you will be able to create a useful set of rules. But here's a process, and I'll just skip this slide and let's go into it. So step one is that you need to learn the context. And what you need to be careful about is the details. And what might be the most difficult part in the context is understanding the mindset and the decision-making style of the executive. And even more difficult is the forces that encourage bad behavior. Okay, and I'll give you two examples. One of them is industry norms, which is first publish, then file in certain industries. And another one is investor beliefs. Okay, if the investor believes something, it's very difficult for the executive not to do what the investor wants, and it might make them believe in it. Now, having nothing to do with this, of course, the company will need IP policies and a good IP culture. The next step is to formulate, and by formulate, I mean make it formal because hopefully it exists. Okay, either what the strategy is of the company or what the different classes of strategy the company might have. Is a company trying to be a monopoly or trying to be a niche? Is it trying to grow or is it trying to destroy the competition? Okay, so that's a class of strategy. And perhaps there's two different steps here. Step one is identifying the company strategy. And step two is when you have the strategy, identifying the touch points between IP and the strategy. And while you're doing this step, you're going to learn a lot of other interesting stuff, which is not part of our process, but is important for helping the company. Yesterday, 2 days ago, I had a call with a client, and the client, I asked him, what is your strategy? And he said, oh, I'm just like all the other companies in this field that are doing such and such. And I pointed out that the other companies have a pull situation and he has a push situation, meaning the other companies that he was using as an example, the customers feel a need to buy it. And in his situation, the customers resist buying his product. So obviously his strategy for making them buy it is going to be different. So you really need to look at it. If you don't know, yeah, typical strategies for similar companies. When you're talking about the strategy and we talked about the company evolving, also the ecosystem is evolving. Today, there's no competition, no market. In 5 years, there's a market. In 10 years, there's competition. We always talk the standard situation about IP strategy being supportive of business strategy. But let us remember that some company strategies, the IP strategy is meant to inform or drive the business strategy. And sometimes the IP is an integral part of business strategy. Now, not always does the executive understand that their strategy is an IP strategy, even if, let's say, in the business of licensing, I'm going to make this product and I'm going to have other people make it for me. Okay, that's licensing. And again, you're going to extract all sorts of information, which is useful for formulating the IP strategy, but we're not talking about formulating the IP strategy, just the rules. Here's a few touch points: vulnerabilities, risks, uncertainties, where IP is created or destroyed, or ownership changes, company structure, challenges. If the company has a challenge that they're trying to solve, we can expect there to be an interaction with IP, either because they're potentially infringing somebody's patent, or because if we can get protection for our way of dealing with the challenge, other people want to buy it. How does the IP help do the strategy? This is not a rule, but if you can identify it, you can explain to the executive why IP is important for him. Okay, explain why IP is important for him, for her, is a different issue from just giving them a rule book to use. And I put this at the very end because that's not our focus. Places where IP itself is being damaged or enhanced. That's the focus of the VPIP. The focus of the executive is the company, not the company's IP. Control points. They're places within a complex system where a small shift in one thing can produce big changes in everything else. So every time I mention it, I say that I don't like talking too much about control points, but it works really well with heuristics. And I give you 3 examples. If you can identify a choke point, something everybody needs to do, that's a place where we want to apply IP. We want to make sure that the executive knows that when they identify a choke point, they should think about IP and at the very least call up you. Another example is external forces. Another example is pressure release points, which cause people not to engage the product. Each one of these are control points where controlling them changes how people can make money. And we want, and I'm going to talk about it in another minute, helps the executive identify that they got to one of these control points and recognize that IP can give the controls that they need, either for them or against the competition. So we've done all of that. Now comes the tricky part, and it's an abductive method, which means that I know it when I see it instead of the other way around. And you need to find rules which can actually be applied. And one way of doing it is RPD. There's a field called naturalistic decision making, which purports to explain how experts make decisions in real life. And a framework that they give is RPD, which is recognition prime decision, meaning I recognize a pattern, and because I recognize the pattern, I know what my decision should look like or how I should make my decision. And if we follow that idea, it means the rules should have a trigger which can be recognized by the executive without a lot of training and without experience or data which they don't have. And it's the impact of the decision is also clear. So let me give you an example of a rule which I wish everybody followed, but doesn't fall in the framework of what I'm talking about. Does this have an IP aspect? Okay. Any decision coming to the executive, he should be asking, does it have an IP aspect? But that's only a rule for calling in the patent attorney into the room. It's not a rule that the executive can use themselves. Okay? So what we're really doing is we're trying to ask ourselves, what decisions does the executive make, and how can IP support these decisions or affect these decisions? And the pattern that we want to give is going to be something that can be recognition prived. So here's some rule classes, not individual rules. Don't damage your assets or protect your competitive edge or shape the game. These are not rules, but classes of rules. Rules that you apply when you get new information or when you're making a decision or when you're doing planning. Even if we talk about shaping, who are we shaping? Us, others, or the game? And here's a kind of class of, can IP increase our control resilience of something everybody needs? A choke point, making things hard for a competitor. These heuristics are only good if they're actually recognized. So a rule that starts with potentially patentable invention identified is not so good because that's our job, not the executives. And they might not know how to do it. But I'm sure any executive can recognize a rule that starts with new strategic partner, or we're about to reveal something that took 6 months to solve, or we discovered that customers get an improvement when they use one of our features, and we use the improvement to make our feature better. Okay, these are rules that we can definitely expect an executive to recognize immediately. And one way of testing it is this a statement, a sentence that the CEO would naturally say before they meet the patent attorney? Okay, they're definitely going to say a competitor asked for access to an API before they talk to the patent attorney. So it means we can't have too many rules, so maybe we're going to need to have a budget for the rules. Talk about that in a minute. What actions do you do? Here's a few examples for actions. Don't sign until we preserve the ability. Don't give the customer enough information. Give away the IP in order to shape the world. And if you look at this whole process I've been talking about, what you see is we have some sort of diagnosis. We have some sort of guiding policy, which is hiding inside the company strategy, like our moat, competitive advantage, flywheel. We identify the relevant control point. We then identify a recurring, recognizable situation, and then we build a rule. So we did all that, and guess what? We got 152 rules for a company. So we have to prune ruthlessly in order to meet this definition of sin playbook. And here's really two ways of looking at it. One way is how important is the rule, and another way is how often will the rule be used. And whichever general direction you use, or maybe a combination, I'll give you a formula, you have to remember that these rules don't replace the IP manager. Meaning, if there's a regular IP strategy meeting, any issue that would come up in such a meeting, or any policy which is applied by the IP manager, they don't have to make it into the rule. And therefore, we should perhaps be looking at people who create strategy and make decisions and do it not when they're meeting with the IP people. And I mentioned important. So what if there's a small number of situations where what the executive does will really change the future of the company? Even though it happens once a year, that's what we should teach them. And there's also all sorts of different decisions that the executive might make. I do not know how to advise you to get from 152 rules to 5 rules. Only thing I can say is that the relevant rules change over time. We've made all of these rules wonderful, excellent. Now we need to educate the executive. Why? Because if the executive doesn't use these heuristics, it was all a waste of time. So we have to make sure that the executive can connect to them on a personal level. Perhaps we should give examples from the company showing how they're relevant. And remember, the education is ongoing because these things are changing all the time. I mentioned several times all sorts of outcomes of the analysis, which have nothing to do with rules, but now's a good opportunity to talk about them with the executive, whether it's less important rules, whether it's facts about IP that are especially relevant to the company, whether it's how IP makes a business strategy work. These are things you should educate now as well. And we do want the executive to get better at IP, and applying the rules will make them better. And perhaps more important, applying the rules might make the executive more open to the need to learn more about IP. So, rules and so on, and you might be asking yourself, okay, what's the difference between all of these rule heuristics and strategy? And the answer is at a different level of abstraction. Rules are a mechanism for executing the strategy, and the way I've described them, under bounded attention. Except 5 rules. Richard Rumlett, in his book Good Strategy, Bad Strategy, defines a kernel of strategy as including diagnosis, guiding policy, and coherent action. And I just want to point out the guiding policy is business, but the rules that we're giving have to do with the impact of the guiding policy on IP. So the kernel is, what are we trying to accomplish and how? And the rule is, tomorrow, what should I notice and what should I do? And here's another table comparing the two in case you think there's strategy sounds a lot like these rules. Skip that. And you won't believe AI can help. It can identify risks. It can simulate what might happen. You can consider that AI itself is an executive. AI is an audit function which can identify when the rule should have been applied. Okay, that's super interesting. So I had AI actually do it. I said, AI, read my incredible presentation, tell me it's wonderful, and apply these rules. And I gave it to Claude, and then I took the output from Claude and gave it to ChatGPT. And ChatGPT wrote a whole long Megillah explaining why Claude didn't really cut it, but he pointed out this distinction. Claude was looking at business facts, IP mechanism, executive rule, while what we're really doing is we look at recognized business event and then executive action, and the IP mechanism is somewhere else. In any case, it prepared 3 rules for SpaceX, a company we all know, and 3 rules for Deep Reach, a small startup that we don't know. Okay, and had a little bit of discussion, and we focused these rules. This is examples of the rules. If we could tell Elon Musk only these 3 rules, it would be wonderful. I suspect he knows them already. Okay, in conclusion, it is possible, I haven't proved it yet, that personalized IP heuristics can help executives apply relevant IP thinking. They don't replace the need for IP advisors. On the contrary, now IP advisors have to also create these rules. You want it to be as personal as possible. Not only executives need them. And overall, the message is that we embed IP into executive pattern recognition so that the decisions that affect IP take IP into account because they identify when the business decision is being made. And if you have a example company called Metlays, and guess what? What are your IP related challenges of the strategy? And make heuristics. That's really what part of our job should look like. And of course, it's going to change when Metlays finds product market fit. The issues will be completely different. They won't be have to do with getting technologies that works and doesn't infringe and is protectable. It will suddenly be how do we keep competitors using ultrasound from competing with us? I'm now stopping the recording and opening the floor to questions, comments,